Hi, I'm Paul McConnell Family Law Group, and I'm going to talk to you about jurisdiction. We get a lot of calls regarding jurisdiction. That is, can we even help you? You want to get an answer whether we can even help you before deciding whether to proceed with a consultation or not. And unfortunately, we often get the answer, it depends, and we require a consultation. So I'm going to talk to you a little bit about why that is. With respect to jurisdiction, jurisdiction is one of the most complicated areas of family law. There's subject matter jurisdiction, there's personal jurisdiction. Jurisdiction, whether that is can Connecticut courts even resolve your matter, is different with respect to divorce and or alimony modification and or child support and or custody and visitation. And there's different criteria and different analysis for each one of those categories. So again, jurisdiction can be particularly complicated, and we really need to dive into the facts to be able to answer you and provide an answer. So I'm going to give a little bit of an overview of some of the law that pertains to jurisdiction. Obviously not all of it. First, as I said, it differs in different categories, but the first one I'm going to talk about is divorce, dissolution of your marriage. Not talking about if you have kids, there could still be a separate analysis, and we'll talk about custody in a moment. But first, with respect to marriage, this one's a little bit more black and white. And that is, in Connecticut, the courts want to require that one of the parties, not both, but one of the parties has resided in Connecticut for 12 consecutive months prior to the date of dissolution or the decree. Okay, so if you just moved here a month ago, you can still file for divorce in Connecticut, but you won't be able to actually get divorced until that 12 months. Until you've been in Connecticut for 12 months. In another video, we tell people to plan on about 9 months, so oftentimes this particular criteria is not overly cumbersome. And that's really similar in other states as well. They have different waiting periods. They have 90-day waiting periods, 6-month waiting periods. Sometimes you got to wait a year to even file. Different states are different, but Connecticut is one or more of the parties have lived in Connecticut for 12 consecutive months. There's some other bases, but that's by far the most common that we see. Now, if you have children, there's another analysis with respect to children, and this can be either in conjunction with a dissolution proceeding, a divorce, or separately. You're already divorced, or you were never married, and the analysis is different with respect to children. The statutory framework in Connecticut and really all 50 states have adopted some version of the UCCJEA, which is the Uniform Child Custody Jurisdiction and Enforcement Act. That's the framework that courts look at to decide if courts have jurisdiction to make or to enter orders with respect to custody and visitation. There's another important law, the Parental Kidnapping and Prevention Act, the PKPA, that comes into play sometimes if a parent's worried that the other parent's going to flee Connecticut to another state with a child or children or overseas. So occasionally that comes into play. In both cases, the courts in Connecticut and the states begin their analysis with deciding, is there a state that has home state jurisdiction or a home state for the children? And the primary basis for that analysis is, where have the children lived? Have the children lived with a parent for 6 consecutive months or more in a particular state? So if children have lived here for 6 consecutive months with one parent, then Connecticut will be home state. Or if they lived in another state for 6 consecutive months, then another state will have home state. That's part of the analysis. Is there a home state? That's obviously not always the case, not in this transient society that we lived in. And it has to be the 6 months next preceding the filing of the action. So it's not just 6 months once upon a time in Connecticut, but they now live elsewhere. It has to, if you want to file in Connecticut under the home state analysis, it has to be present. If there is no a state, or no state has home state, then the next consideration is that courts will look at is, what are the significant contacts? Is there significant contacts to the state even if they haven't been here for 6 months, 6 consecutive months? Maybe they lived here for part of the time. Maybe they've been in and out in transit, but what other family members live here? Are there doctors or schools and or friends and the like that live here? So there's a whole host of significant factors that courts will look at to see if Connecticut or another state has jurisdiction. In some cases, it's not uncommon that one or both states or more than one state will have jurisdiction under the significant contacts analysis. And then it's going to be really a matter of venue and preference. And if it's litigated, there'll be evidence presented in one or more states, and the judges will literally talk to one another and decide which state is more convenient or the best state to litigate and hear the case. And the other state will not necessarily close your case or close the file or dismiss your case. They'll just put it on pause while the custody and visitation proceedings progress in another state. It is a consideration first to file under that analysis, but it's not an overriding consideration. Sometimes somebody might have filed in another state first, but still under the significant significant context test, the state that filed where the papers were filed second still may end up taking jurisdiction to decide the case. Another important component, though, of this is a cost-benefit analysis. For example, we had a case that we litigated last year where there was we represented a mother. The parents had never been married, and the child was born in Connecticut, and shortly after birth she moved to New York City. And then there was competing actions in both New York and Connecticut. And the father, who still resided in Connecticut, wanted to be litigated in Connecticut. We were representing the mother in Connecticut courts, who wanted that action to be put on hold while New York's courts would take jurisdiction. And after a significant amount of litigation involved, we had to fully brief it, argue it. There was over a day of testimony between the parents and other witnesses before a court decided. And in that particular case, I'm happy to report that the court decided on behalf of our client, but I got to tell you, it was a close call. And it could have easily gone the other direction because of the closeness in terms of the competing facts in that case. So it depends, but the point of raising that or giving that example is that there's this cost-benefit analysis. Time is money with respect to hiring attorneys, right? You know that. So we spend, as I said, a day and a half of testimony, all the preparation that goes involved with that, talking to the clients, prepping the case, exhibits and the like. That's a significant cost that was incurred. And ultimately, at some point, a court is going to get to the merits. So this jurisdiction is just a first step before they even get to whether or not there's going to be a custody determination, whether the mother will have primary or sole custody or the father, etc., and what the visitation will be. So even before getting to the merits of the case, the court has to decide jurisdiction. So sometimes you have to do a cost-benefit analysis. Do we want to expend this time and energy and resources to get this determination when there's competing states? How important is it before we get to the merits? In some cases, it is important. As I said in the example I gave you, it was really important in that case for that mother. So jurisdiction is very complicated. It turns on the facts. It starts with a consultation, not just talking to our intake specialist to try to get a quick answer from an attorney, because more often than not, there's no quick answers. The best thing to do is schedule a consultation with one of our attorneys. Fill out the questionnaire and put your facts in there as it relates to jurisdiction. The attorney's going to look at that before the consultation. And if you are one of the cases where it is an easy answer, okay, rare, does happen, then we'll tell you. And the attorney will say, we can't help it. We can't help on these facts. And we'll tell you and we'll refund your money. On the other hand, more often than not, it's a little bit more complicated. And we need to dive into the facts with you and the details of the facts. And then together go through a cost-benefit analysis and make some strategic decisions. And then if it turns out the strategic decision is to litigate it in another state, we're more than happy to help you find an attorney in another state, and we're probably more qualified to help do that, find a good lawyer to help you than you are on your own, just relying on Google and the like. So again, we're happy to help you. Call the number at the bottom of the screen. We'll be happy to dive into your facts and answer your questions on jurisdiction. Hopefully this helps demonstrate to some degree anyway why it's complicated and we just can't give you a quick answer over the phone. And together, if you meet with us, hire us, we can help you find peace through strength.